The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Will the clerk please call the case?
This is Supreme Court case number CRA21-009. The People of Guam Plaintiff Appellee versus Philip James Sablan, Defendant Appellee. My apologies. Appearing for the plaintiff appellant is attorney Sean E. Brown. Appearing for the defendant appellee is attorney David J. Highsmith. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Brown reserves 5 minutes.
Good morning, counsels. At this time, the court will recognize Assistant Attorney General Sean Brown. Mr. Brown, you may proceed.
Chief Justice, Justices, opposing counsel, may it please the court. There's really three main issues of contention for this appeal. One, the trial court abused discretion in striking MTG's testimony. Two, defense agreed to the method and manner of curing that issue. There was a curative instruction regarding the motion to strike and what was struck, and they agreed to the language inside that curative instruction. And finally, the trial court abused its discretion in granting a new trial. Regarding the testimony that was struck, MTG did testify to the elements of the offense. A good portion of that was struck by the trial court, and that was based on 404B, a ruling that was 404B evidence. However, very clearly here, defense has repeatedly admitted that they obtained the discovery and was on notice months, up to 6 months prior to the trial, that the victim may have said there's earlier instances of conduct. I think it's attached to the supplemental excerpts of record at page 7, the actual page of discovery, talking about the other instances. So in that page of discovery at SER 7, it talks about the MTG talking about being molested by Sablan when she was 4 to 8 years old. But what's even more helpful in that piece of discovery is that in the same document, MTG describes to the AG's office investigator that the towel incident and being touched just before the case got charged were the same incident. So going into trial, the prosecutor, the government, thought it was the same incident. That's the way it was indicted. But when she testified, clearly there's some issues with the time frame. She was a 9-year-old girl. So first off,
he was acquitted of the indecent exposure charge. And isn't there sufficient testimony with the unstricken testimony to support the conviction? Even without, you say the trial court abused its discretion in striking the, some of the testimony that was put forth on 404B purposes, but just looking even at the unstricken testimony, it seems at glance that the evidence there was at least sufficient before the judge granted the motion for a new trial to support the jury's finding.
The people fully agree with that. We believe that even if the evidence is properly struck, the new trial should not have been granted. I think not just based on MTG's testimony alone, but also Lena's testimony, which corroborated what MTG had said and was independent evidence that she was touched just before May 2020. And it was always consistent where she was touched, in her private area, not her breast, not her buttocks, but her private area. So I believe even if you consider what was struck, there was sufficient evidence to deny a new trial. But yes.
And in this case, the trial court said it was acting as the 13th juror. But, in People versus Messier, which the trial court did not cite to, we made clear that trial court shouldn't serve as 13th jurors, that motions for new trial that are based on the weight of the evidence, in weighing that evidence, the trial court shouldn't grant the new trial just based on the disagreement with the jury's credibility determination, unless it was an exceptional circumstance. The judge here found that there was an exceptional circumstance. But how do you reconcile the judge's finding in this case with our opinion in Messier?
Your Honor, in Messier, not only did the court say the trial court should not act as a 13th juror, and that's exactly what the trial court indicated it was doing, but it also put other standards in there which are very high. Exceptional circumstances include testimony that defy physical reality or patently incredible. That's not the situation here. So in Messier, this court not just said don't make those credibility decisions, but the standard is very high if we're going to grant a new trial. But here, MTG did not defy physical realities. Lena's testimony did not defy physical realities. Even the defendant's own written statement and the testimony by MTG's father was not patently incredible. So I don't know. I believe that the Messier case, which is the most recent, it's more recent than the Leslie case. It's more recent than I think the other new trial matter. This is the most recent case we have on the issue. So I believe that the very express language, which happened more than 6 years ago, that's the trial court should not be the 13th juror.
And that was the first case that we addressed where a court had actually granted a motion for a new trial, as opposed to the other cases where the court had denied the motion for the new trial and it was up on appeal. But even if we do that, the trial court had an alternative ground or an independent ground for granting the new trial based on what the trial court felt was an insufficient instruction to cure the striking of the testimony, to basically looking at it as a variance from the indictment, because the trial court pointed, hey, the testimony was heard on a Friday. The counsels argued this issue. I made the decision to strike some testimony, but that wasn't done, and the jurors weren't notified till I think it was 4 days later. And so the trial court was concerned with that. We're not sitting in the trial court's shoes, obviously, and we've said before as well that we should give some deference to the trial court. They have significant discretion, and we should give them, deference. Why shouldn't we do that here?
Your Honor, the people agree that a trial court needs to have a huge amount of discretion in these issues. However, there's still an abuse, and that's because there's two parts to the jury instruction, the curative. One, the testimony should never have been struck. Two, jurors are presumed to have followed curative instruction, their jury instruction. That's the Uggan case citing McIntyre. So here, there's no evidence that says, there's no clear evidence. There's the thoughts that maybe the jury couldn't follow it, maybe, but we don't have any evidence of that. Here, they're presumed to have followed the curative instruction, but that's not the most important part of this. The most important part of this is that defendant is the one that asked the court to strike. Defendant is the one that his motions required the curative instruction, and he actually agreed to the specific language in the instruction. That's very clear in both the record at trial and both in our appellate documents. And in the White case, this court said, whatever party procures a court to act is precluded from assailing such ruling. That curative instruction was good up until a guilty verdict came back. Then suddenly now the curative instruction is no good. If there was an acquittal, everyone would have been fine. That's a great curative instruction. But because there's a guilty verdict, now suddenly the defense saying the curative instruction was insufficient. And furthermore, they actually defense talks about jury instructions that are boilerplate.
Yeah, but the motion for new trial won't be filed till after the verdict.
I understand, Your Honor, but how can they base a request for new trial that the jury couldn't disregard the struck evidence that the curative instruction was faulty if they agreed to the language? How can you say I'm fine with the language for the curative instruction, but now it's insufficient? They could have filed a request for mistrial before that if they thought that the jury was too infected with what
I
the struck evidence was.
think the trial court was struggling with that as well when it said, in her mind, it wasn't going to be clear to her based on the testimony, to the jurors, which incident would form the basis of the conviction and potentially expose him to double prosecution because of the fact that, the indictment and the discovery and everything that she had looked at suggested that the incidents occur on the same day, or was part of one incident, even though there were two criminal acts.
If we look at SCR 7, again, the discovery indicates that the towel incident and the touching incident were one and the same. That's SCR 7 on the defendant supplemental excerpts of record. And the court is right. Maybe it's not clear, but again, the jury's presumed to have followed the curative instruction, and the prosecutor, in this case, in closing, elected what date it was pursuing. Not only did we reduce it from, like, a lot of CSC cases with children have year-long timeframes. Here, it was only 30 days. And in closing, I actually told the jury this happened on or about April 15th, 2020, the last weekend or so, or the time period before they stopped going to the defendant's home. So they only had one date or one evening of possibility to say, did this happen on that time frame? So in a lot of the case that goes into this, maybe there's some confusion because there's a lot of time frame here, but here it was just one incident. So the prosecutor elected a very specific time frame that was supported by the text message. Not just MTG's testimony, that's the huge part here. The court didn't really acknowledge all the corroboration and all the supportive evidence. There's a text message that was admitted into evidence that's attached at SER 12 that highlights the dates where the family was there. So, and Lena testified that the victim walked into her office crying. She asked her what happened. She said, the weekend before this, Sablan was touching me. He stole my underwear and exposed himself to me. So we have a time frame. We also have exactly what occurred. So the court did not do a thorough job of applying the corroboration and the evidence that gave MTG credibility. If we were not relying solely on MTG's testimony to ask the jury for a conviction, we were relying on Lena's testimony, the defendant's written statement, the MTG's father's statements. All of that gave us the specific time frame. There was no confusion as to what factual allegations were applying to the indictment. Like, for example, in the Titano case, which is very distinguishable from this case, it was a year-long time frame. And the victim in that case said nothing happened at the Manila residence, which was the indicted charge. Here, the victim never changed her opinion on where this happened or who did it. It was just simply a confusion as to what time frame there was. But luckily, in our case, we had very much clarity from the other witnesses and other evidence at trial, the time frame. In the Titano case, there's also a motion filed pre-trial.
The standard that we're evaluating the trial court's decision is an abuse of discretion. She goes to, I think, pretty detail about why the testimony that remained, and is distinct and from, all of these. She called it, I think, voluminous and complex testimony. And so she thought that the stricken portions and the unstricken portions could have got muddled. And even though she recognized the curative instruction, she herself had doubts whether the jury could distinguish it, and especially because it was several days before that testimony was withdrawn, and she felt that the stricken testimony was highly prejudicial, and the competent evidence that remained wasn't necessarily overwhelming, I think was what she said. But she at least seemed to set forth a pretty detailed rationale, and in looking at it under the abuse of discretion, she applied the standards, explained her reasoning for granting a new trial. Why shouldn't we look at accepting that under this abuse of discretion? How did she abuse her discretion?
Two, she made credibility determinations without giving deference to what support in the record gave MTG credibility. She acted as a 13th juror, which in the Messier case said should not happen. If this case was a close call, which the people argue it's not, based on, again, the testimony of the defendant's written statement, Lena's testimony about being told exactly what happened, and the father's testimony confirming all that. If this was a weak case, the jury should still be the one to decide if they're going to believe MTG or not. not the court saying the girl's testimony was confusing and
Well,
hard to
she had
understand.
two grounds for her decision. One was the witness's credibility preponderating against the sufficiency of the evidence. But the other dealt with the striking of the prejudicial testimony and the confusion that was going to result. So it really wasn't based on the credibility side. I understand, and I think that the trial court did not even cite to Messier, didn't cite to the appropriate law for evaluating when exceptional circumstances exist because of witness credibility. But that is not the same, those same weighing of the credibility doesn't apply to the decision she made on the prejudicial, what she viewed as a prejudicial testimony that was stricken.
Yes, Your Honor, but her new trial, the grant for new trial was based on that the evidence should have been struck. And here, there was definitely portions of the struck testimony that were improper. The prime example of that is on cross-examination, defense asked MTG, didn't this happen when you were 4 years old? On cross-examination, defense attempted to get into prior bad acts. If the victim was 4 years old when those prior acts happened, this is defense question, that would have been 5 years prior. What is a touching that occurred 5 years prior to trial? That is a prior bad act. The defense asked that question of MTG. I go back on redirect and I say, okay, let's clarify this because clearly we're creating confusion here. And then I talk about who your teacher was, and she's about to talk about Mr. Canado. Mr. Canado's her teacher in second grade, which would have clarified exactly when she was molested. What did the court do when I went on redirect? It struck that as well, which was very perplexing to me because that was the defense question. The defense intentionally asked the victim about prior bad acts, and the court still struck my redirect.
So you're arguing if we agree with you that the stricken evidence should have been admitted, that then the trial court's decision saying that there was confusion on the juror wouldn't matter because
100%.
that evidence would have been admitted or should have been admitted, and then therefore the fact that the jury may have relied on that evidence would be harmless. Somewhere
I cite in, I think, my opening brief, there's at least one case that says if there's a curative instruction and the struck evidence was never supposed to be struck, then we can still be fine going forward. So I forgot exactly where I put that in my brief, but there is at least one case that talks about that very issue where there was a curative instruction, testimony was struck, but the testimony should not have been struck. And therefore, there's still a basis for sufficiency of the evidence. And we also talk about, I think in the Mateo case, we talk about if there is a striking of evidence or evidence was improper, the jury still got to consider it, and we shouldn't be assailing the sufficiency of the evidence based on that. So there is at least some case law.
That was the state versus Peabody was the case that you cited, and you said that the rule from the impact of prejudicial inadmissible evidence would not apply where the admissible evidence was erroneously stricken because it wouldn't affect his rights.
Yes. And in this case, I think there was not 404B evidence. I think this girl was simply confused. She's a 9-year-old girl in a very high stressful situation, testifying in front of a judge, marshals, a jury. She's not next to her mom while testifying. This is scary. And as she even testified repeatedly, she's having trouble talking about not just the sexual stuff, but also about the time frame. She was back and forth on when things happened before or after, but she was very consistent. She was watching SpongeBob. The bag the defendant took her panties in was black. The clothing he was wearing or the towel was blue. The defendant even told officer that the underwear he might have been in that day was blue or green. So the victim was very consistent and credible in many parts of her testimony, which I don't believe the court mentioned at all in the grant for a new trial or to strike. And I think that has to be considered here, that it's a 9-year-old girl who otherwise was consistent except for the issue of time. And she always said very consistently this happened in the bedroom by Mr. Sablan, his hand, and it touched her private area, not her breast, not her buttocks. So, and then we talk about hearsay. I expect Mr. Highsmith to attack that the evidence by Lena and by the defendant's written statement and by MTG's father should not have been considered as admissible evidence. The problem is in the Commodore case, we talk about if a victim is attacked, her credibility is attacked. And here, not only did Mr. Highsmith attack the victim's credibility in opening statement, but when Officer Balahaja was on the stand, he already asked her, okay, how do you know she's telling you the truth? And didn't you know that these allegations occur at night, but Mr. Sablan works at night? So he's already attacking with the very first witness the credibility of MTG. So these prior consistent statements help give support to the victim, and they should be admitted under prior consistent statement. But the thing is, they weren't objected to. So I think there's case law, I think we put that in our brief too, that talks about if someone doesn't object. Actually, I think the judge talked about that when deciding that those pieces of evidence were admissible. And substantive evidence, not just as impeachment, but as substantive evidence. But we haven't, there's not a lot of information here by the court talking about the specifics, credibility and corroboration. In my reply brief, I put very detailed information about where the victim's testimony lined up with other witnesses. And I think that goes a long distance with whether or not the jury should have believed her. And regarding, again, the Titano case, it's very different from, it's very, very different from the case we have here, because in that case, part of it was there was no curative instruction. Here we do have a curative instruction. There's ample independent evidence of what happened in Titano. There was none. And the victim in Titano, again, said nothing happened in Manila, which was the indicted charge. Here, there is no such denying of allegations of the indicted charge by MTG. So I don't have too much more to argue. I think I'll just save the rest for reserve.
All right, Mr. Brown. At this time, Mr. Highsmith, you are recognized.
Thank you, Your Honor. The prosecution has the burden of persuasion here that the trial court got it wrong. They've said that there were three issues. The alleged that there was an abuse of discretion in ruling on 404B, that we agreed to the instruction. That's the second issue. And the third is an abuse of discretion to grant a new trial. Dealing with the 404B issue first, the government just didn't give the notice that it should have given under 404B that it was intending to bring in prior incidents. We asked for it and it should have been given. Now, there was this one-page report, which is SER 7, that says the girl described a prior incident. That isn't notice to the defense that the prior incident will be brought in. And it really, they should have told us. We didn't know that the evidence would be brought in, and they should have told us that. Apparently they intended to do it all along. And this case is rather like a chain reaction from that point on, where they tried to introduce the 404B evidence. That's when things started to go wrong. And everything that happened.
Government says
that
the government says you did get notice of the evidence when you received the pretrial discovery that contained the prosecution's interview explaining that she had not been touched only one time.
I don't believe that's
satisfy
notice.
the 404?
No, I have not seen a case that says that. We got a one-page interview, and we didn't get anything in court. It should have been filed. All they had to do really was file one page in court that said, we're going to introduce evidence of a prior bad act and perhaps refer to this report. But we went to trial thinking that that was not going to happen. And the court found that we were misled to our detriment by that. Looking at the indictment, which says April 1st, April 30th, 2020.
The government says the evidence is also admissible for non-character purposes to show that the victim was confused about the dates. And therefore, there's another basis for getting some of that stricken testimony admitted.
I'm not sure they argued that in the trial court. They might have. The arguments about 404B went on a long time. I wish this had all been put before the court before it was, because that's how things got on the wrong track. We could have argued that point. It could have come in to show her confusion about the dates. I don't know about that. It seems to me 404B prohibits prior bad acts, except in certain limited situations, like modus operandi, intent, none of which apply here. So really, any problem with 404B can be laid at the government's door. All they had to do.
Besides the prejudicial testimony as a grounds for, or the striking of it as a grounds for the granting of the new trial, the court also looked at the credibility and the preponderance of the evidence and sat as a 13th juror. But the court didn't cite our opinion in Messier, which I think, sets forth our standard when you're looking for granting a new trial, when the jury has made a credibility determination, and when the trial court should step in and act. And it really comes down to very exceptional circumstances where, it's, as we, I think, said, patently incredible or defy physical reality. And the testimony you have here that doesn't seem that, the little girl's testimony about the touching that occurred, and, she pointed to him touching her in her lap area, in her private, she said, I think, that doesn't seem to fit within that patently incredible or defying physical reality. So obviously there's the earlier decision in Kanata, but that's a much older decision, and Messier is a more current one. And so, the trial court didn't seem to get that standard as we set forth in Messier.
Well, the victim's credibility wasn't exactly the problem. The court found that if you read the first part of the DNO, that there was evidence to support the verdict, viewing the evidence in the light most favorable to the prosecution. It never really came out and said that the girl was not believable per se. It said that there were confusion and contradiction in some things she said. If we look at her testimony, first she said it didn't happen. She talked about the stolen underpants and the towel business. But then she was asked, did it happen? She said, no. And the prosecution kind of had to worm that out of her. And then she said it did not happen the same day as the towel incident. Then she said she fell asleep on a bed, and that it happened in the nighttime when nobody was there. But there's some evidence that the family always slept in a different room. Right? And that may take us into the realm of impossibility. I call the court's attention to ER 54 and ER 38. And she differed on whether she was sleeping in the same bed with her Aunt Lena. That's what concerned the court. And it's obvious from a reading of her testimony that she couldn't differentiate between these different incidents. You don't know which one she was talking about. Now, the law says that the court may grant a new trial when there is a possibility that a miscarriage of justice may have occurred. Not that it actually did occur, but that it may have occurred. And the court really got that right. And I would like to emphasize here that the government is talking about two abuses of discretion. First, the 404B decision, and secondly, the decision to grant a new trial. So they're arguing that there was an abuse of discretion piled on top of an abuse of discretion. That makes their case all the more dubious. I'm not even sure how much the 404B decision.
Well, I mean,
can
we
be
could
reviewed.
still make a determination that the trial court didn't abuse its discretion in admitting or denying the admission of the 404B evidence, but then say that the trial court abused its discretion in granting a new trial.
Well, that's theoretically possible. Yes. I think the core of this case is the court's finding, which I suppose is a mixed finding effect and conclusion of law, that the instruction was not effective because it wasn't given promptly. It was given 4 days later, and ordinary people sitting on a jury may have confused everything in their minds, just as the girl's testimony kind of hopped all over the place. Now, we agreed to the instruction. The form of the instruction was adequate. It's kind of a standard jury instruction. But what the court found was not that the instruction was inadequate, but that its timing was inadequate. That giving it 4 days after the evidence was heard, and actually some of it 5 days, because I think some of the girls' testimony was on a Thursday, not on Friday, that the jury probably couldn't differentiate these things in their mind. Just read the account of the girls' testimony in the prosecution's brief. It goes here, it goes there. How can the jury possibly separate those things? After 4 days, they go home, they think about international affairs, whether their kid needs braces, going back to work on Monday, or I mean, going back to whatever they do the next week. It's impossible to believe that they got that right. So
What about the presumption that they're supposed to follow the instructions? You know, you give the instruction, the jury's presumed to follow their instruction. We have a slew of case law that suggests that.
Yes, but there are also cases that say, and I've cited several of them, that the introduction of prior bad acts can be grounds for a new trial, even if there is a curative instruction. And most of those cases are federal. They're brought under Rule 33 of the Federal Rules of Instruction. I'm sorry, of criminal procedure. But this court has already said that it will look to the case law on Rule 33 to interpret our Section 110. There are a few other points I'd like to make. For Messier.
What about the fact that just even with the admissible testimony, there was sufficient evidence to convict? I mean, you point to evidence in the cases that you had cited about there being a strong likelihood that the effect of the evidence would be devastating to the defendant. But if there's sufficient evidence in the record independent of the stricken testimony, they talked about the corroboration from the other witnesses, her own testimony to support the verdict, and then it seems that the instruction on whether to disregard inadmissible evidence was that crucial. And Mr. Brown, in his opening brief, cites to that case I mentioned earlier, I don't have it up in front of me, where they said even if the evidence wasn't, inadmissible, I think, but that you shouldn't, the jury couldn't, or the case was if it was otherwise admissible, then there wouldn't be any harm to the defendant.
Well, you're
But
under
here
the,
you have some testimony that clearly was admissible that could support the verdict.
well, the court found, and once again, I think this is a mixed finding of fact and conclusion of law, that the girl's testimony on the point was minimal. And of course, anything else was hearsay and secondary. Despite what the government says in its brief, Lena did not really corroborate anything on the date when she testified. Her mother did not say it happened during the month of April. I call the court's attention to ER 48 and 53. The father said nothing about the date either. He said, she told me it happened, but he had no details as to what happened. This corroboration, so-called corroboration, is not strong. It really, it doesn't lend credibility to the girl's story. The girl told the same story. Well, she didn't tell the same story, but a similar story to everyone. And who knows whether she was talking about April 1st to 30th or 4 years before. The whole story about the stolen underpants is dubious because Lena testified, and there was no question that the girl leaves clothes at the house, including underwear. We talk about whether it goes into the realm of impossibility. Lena's testimony, if it's accurate, said the girl said it happened on the previous weekend. That was impossible because they weren't there on a weekend. The weekend would have been May 2nd to 3rd outside the time frame. See, going back to the 40B argument, the court can't really show why this was wrong. I'm sorry, the government can't really show why this was wrong. The notice was not given, and the government has not pointed to one of those exceptions under 404B that this court has ruled in 404B cases, the evidence must fit under before it comes in. And then you have, after the 404B analysis, you have to go into 403. This court has also said that. So the government hasn't really made a proper argument about the prior bad acts evidence. It should not have come in. The court was concerned because it could not say whether the defendant was convicted on admissible evidence or inadmissible evidence. There are cases about jury instructions. They're admittedly in the minority that say that jury instruction is not always effective, that sometimes the jury doesn't follow it, even though they are presumed to follow it. But they're there. And is the evidence devastating, as some of those cases say? Well, it is. 404B evidence is some of the most devastating evidence there can be. The court considered all these things very thoroughly. As it sat through the evidence, it watched the jury, it heard everything. This court cannot put itself into the mind of the trial court judge, except through the DNO. It wasn't there. And the standard is a very high one. Abuse of discretion is not something that happens very often in our court system. The judge was very thorough. This is not like Messier, where the judge ignored genuine corroboration from independent sources, where the judge didn't think about all of the evidence. And Messier goes only to the weight of the evidence argument. It does not go to the second prong of the material variance problem. Material variance involves two problems. One, was there a lack of proof? Two, was there a lack of notice and double jeopardy? And I think it's the second prong we're concerned with here, because the court felt that the defendant was misled to his detriment, to his prejudice, in other words, by there not being notice given. And that puts him at a tremendous disadvantage going into trial, because we thought we were going there on one charge and one charge only. And he is open to another trial, because if they re-indicted him, the statute of limitations has not run, because the statute of limitations for this kind of a crime doesn't run until the child is an adult. But there is a possibility of another charge here, and that's the double jeopardy problem. What I'm saying here, Your Honor, is let's go back to the trial court and do this right. And if he's convicted again, we'll know it was a genuine conviction, because all these problems will be straightened out. If they think the prior incident is that important, they could give us notice and we'll prepare for it, and we'll have a cleaner record, a cleaner trial. I don't have too much else to say, Your Honor. I'll save the remainder of my time for questions if the panel has any.
Mr. Highsmith, you said that the new trial would cure the double jeopardy issue if there is another incident. I'm not sure I understand how that would be.
I hope I didn't say that. No, if I don't think it would, unless he were re-indicted for both incidents. I can't speculate about all that. I'm not. What I'm saying is, if we go back and do this right with a notice and another trial with another jury, and we can prepare, then we'll have a clean record, a clean verdict, which we don't have now. We have a very complicated and confused record, as the trial court found.
Thank you.
Thank you, Your Honor.
Any other questions for Mr. Highsmith? If there are none, Mr. Brown, you're recognized for your rebuttal.
Thank you.
Thank you, Justices. Mr. Highsmith has talked about how the victim's testimony at that trial was confusing. And she did confuse the allegations when we talked about it. And when I asked to use leading questions so that we can steer away from anything in the past, the court said no. The court rejected that idea to use leading questions for a 9-year-old testifying who was clearly confused. But when she talked to the police closer in time to the allegations, and to Lena Gustav, closer in time to the allegations, and her parents, she was very specific about what happened. And the jury heard those statements without objection from defense. So the jury heard the specificity she had close in time to the allegations. And those things were admitted as substantive evidence, not hearsay or not impeachment alone. So they heard that a weekend before May 5th, the victim was touched by Mr. Sablan in her private area, as well as having her underwear stolen, and that he exposed himself to MTG. So the jury heard those things independent from what was struck or what was not struck. And there's a reason why those statements are always crucial in these types of cases, because children or adults, years later or months later after an allegation, will forget when it happened. If an assault occurred on someone's birthday or on Christmas, it's much easier to recall those things. But if it recalls on some random date, how are we going to expect a 9-year-old to say this is when it happened? But when she first reported it, she said it happened last weekend. That is detail, that is specificity, that is credibility. If that was not admitted, I would understand Mr. Highsmith's claim here that there was credibility issues, or the judge's claim that there was credibility issues, but that's not the case. The case is not only do we have Lena's testimony, but we have MTG's father's testimony that corroborated that she was emotional that day, that she was in the office, that Lena said, "Girl, what's wrong?" And that's when these allegations came out. The girl didn't go running up to somebody and say, "Someone listen to me, I have to tell you something." No, she was there sitting there crying. And one of the aunties asked, "Girl, what's wrong?" And that's how this came out. That shows a lack of bias. There's testimony that MTG loved Lena and she treated her like a second mother. Why would she make these things up? The court didn't go into that either about motivation. There were, I think in the opposition brief by Mr. Highsmith, they were talking about how some witnesses said MTG was lying. But those witnesses were biased because Mr. Sablan helps take care of their brother. He provides assistance. So they have a reason to say these things. And when Lena testified that she was present during the underwear incident and that she was present during the phone call, why in the defendant's written statement was she not there? So it was very obvious to the jury that Lena and Panina Gustav were sitting there on the defendant's side and saying things that were outrageous, versus MTG, who was simply confused about the time frame that these things happened. But she wasn't confused a year earlier when she told Lena and her father and Officer Balahaja what happened to her. And when we talk about the surprise of the 404B, the notice, the statute says written notice. What does Mr. Highsmith admit that he has? Written discovery about the prior incidences. He acknowledges that he could have filed a motion to eliminate at some point to address these things if he wanted to. The people did not intend on getting into that testimony. For example, the discovery says it happened on the same date. If she didn't struggle with the memory, her answers would have been very clear cut and we would have been moving on. Or if the trial court allowed me to use leading questions, we probably could have moved on from there. Say, listen, we're just talking about the weekend before May 5th, right before you guys stopped going there, but I wasn't allowed to use leading questions. So we're talking about surprise. The defense was not surprised by those allegations because in his own during trial, he said, I want the air mattress incident in. He talked about in opening statements that MTG had many, many different stories of what happened. So he's aware of these things. He's acknowledged them. He's prepared to address them. And finally, he opened the door when he asked MTG, this happened when you were 4 years old, but I wasn't allowed to get back into that. This is not an intentional attempt to surprise the defendant. Again, we thought she was going to go with what was in the discovery, and we're going to talk about the final incident before they stopped going there. And yes, there was more than one incident. Taking of the underwear, the phone stuff, the shower stuff, the touching. So it didn't have to be a prior touching when we talked about other instances. It could have been anything. It could have been anything she wanted to talk about. And it's hard when you have to say open-ended questions to a 9-year-old, what happened to you? What are you talking about? And you could see the way the attorney's questions were beyond her. She admitted that. She's like, what are you saying? She said that several times. When we talk about the rules in Titano, did the proof at trial conflict with the indicted charge? No. We heard that the victim was touched on a private area by Mr. Sablan in April 2020, and that was what the indicted charge indicated. That's what the prosecutor said in closing argument was the elected approach to this. And the jury didn't have any confusion. They were not looking at other charges. They were looking at exactly what was indicted, and they're told and told by the judge not to consider anything but that one incident involving the towel and that touching. And yet they still came back with a guilty verdict. This was not a blind jury that was caught up in emotion, saying yes to everything, and they're just going to believe the little girl and say no to everything else. They acquitted Mr. Sablan of one of the charges. It was a very thoughtful jury. They looked at everything and said, you know what? Maybe he didn't mean to show her his penis. Maybe he just came out of the shower, but he did mean to touch her. Okay, so if we look at all that and we look at the sling of underwear, we have the intent, we have all the elements put forward. And the court did make some mistakes here. Okay, it used the wrong legal basis to grant new trial. It, at minimum, should not have struck my redirect of the victim's testimony regarding who her teacher was after Mr. Highsmith asked for this happened when you were 4 years old. Because if that testimony wasn't struck, that would have given some clarity to the date frame, how old she was when she was touched. But at least that was struck inappropriately. At minimum, the people argue that the rest of it was struck inappropriately as well because the defendant was not surprised by the 404B evidence, but he did open the door to at least that part. So there's that minimum abuse of discretion right there. And that was in part used to grant the new trial. The court failed to consider the credibility and the other evidence that showed corroboration. After indicating that those came in as substantive pieces of evidence, the court ruled that she still didn't highlight how that gave corroboration and credibility to MTG's testimony and independently proved up the charges of the date frame, where she was touched, who touched her, and that there's so many levels of proof here that people were shocked when the court granted new trial. And I'm asking the court, I'm asking this Supreme Court to find the court abuse its discretion, and that the court, the decision in order to grant a new trial should be vacated. Thank you all.
Thank you, Mr. Brown. So, Justice Merriman, did you have anything that you wanted to ask?
Yes, Mr. Brown, the standard for the second part of the court's decision is the possibility of injustice. What is your response to that? You know, to be honest, my concern also is the length of time between when the testimony was given and the curative instruction. How do you deal with that aspect of possible injustice?
So one, there's case law that says a jury is presumed to follow curative instructions. If we're allowed to assail an agreed upon curative instruction, that's going to bring into question a lot of guilty verdicts. People are going to be able
I'm
to say—
not so much talking about the instruction, but the fact that the testimony occurred on a Thursday and Friday, and then they had several days before the curative instruction was given after that testimony was struck.
So I believe juries are also told repeatedly, you are not to consider the allegations in this case unless you are together as a group to deliberate. So that is a standard instruction by every judge when a jury relieves for the day or for the weekend. They're told you're not supposed to be considering these things. Don't do an independent investigation. So there is no proof that they didn't follow the rules. In fact, again, they did acquit the defendant of one of the two charges. So they did make an effort to look at everything in detail. There's no proof that they didn't follow the instruction. There's a presumption that they did. And if they came back with a guilty on everything, it's possible we could sit here and say they weren't paying attention. But right now, the presumption is that they did, even if it was several days later. And they're told not to go home and start deliberating without everybody together as a group. So I'm not 100% sure that was an instruction done in this case. I think it was. I just I wasn't necessarily prepared that we're going to go this route, so I did not check into that. But I'm very confident the jury was told they cannot be deliberating on the case unless they're there together as a group at the end of evidence.
Thank you.
Thank you, Mr. Brown. The court will take the case under advisement, and thank you, counsels, for your arguments this morning. And the court stands adjourned.
Thank you.
Thank you, counsel.
Thank you.